Hey guys, welcome to Lawsplaining the Interwebs with your host, me, Nick Rekieta of Rekieta Law. I'm a rural lawyer in central Minnesota, and I have no interest in the outcome of the case that I'm about to talk about beyond just general curiosity of how the law will go and my own biases on how I think the law should be interpreted. That said, the case I'm talking about today is James Damore versus Google in a class action lawsuit alleging discrimination on the basis of political activity, race, and gender. If you're not aware, I have done 4 videos on this subject already. The reason I'm doing this video, though, merits a bit of explanation. So this is a summary video. I don't normally do these. What I normally do, if you're not familiar with my channel, is I take a legal document or sometimes an article, but let's keep it relevant to this. I'll take a legal document and I will actually read through every line of the document and offer commentary and legal definitions and just basically act as a translator and liaison for people who maybe don't live in this legal world that I am stuck in, that I have chosen as my path in life. So that's how I normally do this. The videos take a very long time because these documents are long and there's a lot of explanation. And then I try to add some spicy banter and my own personal opinions to the mix to kind of give it some flavor, because if I'm being honest, the formula I presented earlier sounds a little dry. So I have covered this document. This is the complaint from Damore against Google. So my earlier coverage got a little more attention than I maybe thought, or maybe not more attention, but I got attention in spheres that I wasn't really anticipating. Apparently it was shared, at least the first video or two were shared within Google, and it was brought to my attention from some concerned individuals that some of the spicier commentary from me was providing offense to some people, and it was creating an environment where people were refusing to share the videos and advocating that the videos not be shared on work time due to things like ableist slurs. I was not aware, frankly, what an ableist slur. I mean, I get the concept of ableist slurs, but I didn't know any of the things I was saying would be taken in that way. That is outside the realm of my average thought. It's so the world of social justice is not a world in which I deal. I deal in legal justice, right? And represent the interests of a particular client on a particular issue. So the idea that me offering some levity and poking fun at someone through a sort of elementary name calling being an ableist slur and then being used to shut down the video was it took me off guard, right? It's not the world that I live in, but I can understand why some people who, again, I did not foresee ever seeing this video or that video, might have taken some umbrage with my statements. And so what I have decided to do is offer this recap, which is going to be a highly condensed version of the first 4 videos. I'm actually going to skip the facts section, the introduction, and the class certification sections entirely. And I'm just going to focus on the legal claims, the 10 causes of action alleged by Damore against Google. And I'm going to provide these sans what I would consider witty banter just try and give that analysis, because what the feedback I've gotten is that there are people within and without Google who would really like kind of a straightforward explanation of some of this stuff, because for some people within Google, right, this has a direct impact on their employment and their lives. This lawsuit does, not the video. Like, the video is just an opinion of a guy. Please remember that is an opinion of a guy who happens to have some legal training and a little bit of time to kind of distill this stuff. But the lawsuit itself has a direct impact on, potentially thousands of people within Google, one way or another. Absolutely. So this is my condensed version that will be really specifically pointed towards tackling these issues, talking about what these issues are in terms of the California statutes that they're referencing, and kind of my excuse me, and kind of my my personal opinions on how these claims stand. Now, it's important to note one more thing before I really get started. This is a document written by a party in a lawsuit. This document, the words I am reading to you, are overtly biased in favor of the author. Or, well, the author is the attorney, but the author's client, right? Sorry, I'm going to adjust that. It's a little weird. They're overtly biased. So, this is the information that I have to work with. I am not a Google employee. I only have what's in these claims and what is in the fact section above. I strongly encourage anyone interested in this to read the document. It's publicly available by a Google search. Interestingly, right? They have it. It's posted up on Scribd. Otherwise, you can actually track the case in the court where it's filed. And if I remember, I will try and post a link to that in the video description. But if I don't, please forgive me. But this is biased towards Damore, by the very nature of the document. So when you see this, if you don't like what you're hearing, take a moment, breathe, and remember that this is a one-sided story. The other side of the story hasn't come out from Google yet. Google's lawyers have yet to respond in this case. When they do, I will personally be covering that. I have a lot of interest in what's going on, because I'll put it bluntly, the facts alleged in the fact section of this document are very strongly in support of Mr. Damore's case. So if this is the sole set of facts, then it's just a question of law and the application of the law. And if that's the case, I think Damore would win outright. Now, nothing is that simple, especially not when you're dealing with a multi-billion-dollar corporation with tens of thousands of employees across the globe. So don't mistake this as me saying Damore is definitely going to win, and all sorts. There's any number of things can happen in the meanwhile. We don't have Google's story on the facts, which I assume will be vastly different. But as the facts are relayed in this document, assuming them to be true, which is kind of how a court has to proceed until someone shows them to be false or misleading, assuming them to be true, Damore does have what appears to be a valid claim against Google on at least some of the causes of action. So with that in mind, with all of those caveats, with the explanation that this will be a video that is absent of my individual criticisms and light insults and jabs, that this will be a review of the legal claims and an explanation of the legal claims. Please watch through this if you're interested in this case, and disregard the other videos if they offended or rankled you or contain some sort of language that that made you uncomfortable, this video will not be like that. So please take the time, watch it through. If this case is interesting to you and you want to know what's going on, this will be highly directed towards that end. And one more mention, there is another document that I will be discussing. And this is a 1986 opinion written by the Attorney General of California. At the request of the legislature. What they were asking at the time was, do the Labor Code sections 1101 and 1102, which are extremely relevant to the causes of action that Damore is bringing against Google, do those apply to, in this case, people openly identifying as homosexuals in a private employment situation? The court at this point had already determined that a public employer, a government or some branch of the state's authority could not discriminate based on sexual orientation, but they had not determined at this point in time that a private employer would be barred from discriminating against sexual orientation. So they asked the Attorney General for this opinion, and he provided the opinion that they believed the Supreme Court would uphold a cause of action against a private employer who discriminated based on sexual orientation. How they get there is Section 1101 and 1102, which protect political activity, and they state that openly revealing sexual orientation is a protected political activity. Now, Mr. Damore is arguing the opposite, that basically heterosexual or cisgendered white males of a conservative or right-leaning political bias or political affiliation are being discriminated against. So this opinion doesn't directly correlate with the case. However, this opinion reviews the law, and it's very informative as to what kind of ideas we can expect from the California court in their analysis. So I will go through that at the end of this because I think it's important to go through the causes of action. My goal for this video is an hour or less. Bear with me. I'm not great at brevity. I charge by the hour. Remember that, please. And let's go through this as well as we can do it. So the first cause of action is a violation of California Labor Code Section 1101. That's exactly what I was just talking about in that memo. That's why that memo is extremely relevant. And let's see what they say about the statute here. So employers, may not discharge or discriminate against an employee for engaging in political activities or the exercise of any rights afforded him. California Labor Code Section 1101 prohibits employers from making, adopting, or enforcing any rule, regulation, or policy that forbids or controls or tends to control their employees' political activities. So California might be, we'll say, ahead of the curve or unique in this, in that political activism is a specifically protected category, even for private employers. So this prevents a private employer from again, controlling the political activities of others. This law was passed in this form back in 1937. It has remained largely unchanged for a long time. And at the time, it was protecting, it was contemplating some employees who were discussing the overthrow of the government. We'll get to this in the memo, but they were not protected in discussing the overthrow of the government, but the court had a lot to say about what was protected, and that's the Lockheed Aircraft Corp. Versus Superior Court of Los Angeles County, and that's kind of a running theme throughout this memo because it's a case strongly in support of Damore's position. So, a violation of this section prevents employers from controlling. Or upon violation of the section preventing employers from controlling political activities of employees, employees have a right of action for damages. Okay, so if an employer tries to control your political opinion, they can't do that, and the employee can bring suit for damages. If they try and control your political opinion by, say, terminating you or preventing you from achieving a promotion in some sort of way, there are specific monetary damages there that can be calculated, right? If you would otherwise be employed at a high-paying job, we can start to tally up what the damage is to that person. So this next section says plaintiffs and all members of the classes engaged in protected political activity. So this is them saying that what Damore and this other guy Goodeman, who's the other representative of the class, and then other class members who have been similarly disciplined or terminated, what they were doing was protected political activity under the statute. This is an argument, right? And they say that they were discriminated against throughout the respective class periods by Google. As a brief aside, the class periods are set up earlier in the document. They basically are a 3-year period going back 3 years from the filing of this document for the political speech activity, and I believe a 1-year class period for both being Caucasian and a 1-year class period for being a male. And actually included in the Caucasian male subclasses are Asian male employees who, from what I understand, have a disproportionate representation currently, or at least some people believe that their representation is disproportionate. I don't have factual data on that. I just have the allegations of the suit, remember. So they're stating that Asian men and Caucasian men are being discriminated against at Google for being Asian or Caucasian males. So that's this first cause of action. What you'll find is that all of these causes of action have similar last 3 or 4 statements. And they all basically say that because of what Google has done, we're entitled to damages. So I'm going to skip those for the sake of time. So second cause of action. This is section 1102 of the California Labor Code. I should mention, the first cause of action is by plaintiffs on behalf of themselves. That's James Damore and whatever Goodeman's first name is. Damore and Goodeman, and the political subclass against all defendants. So this one is Damore and Goodeman and anyone who is conservative at Google, or right-leaning. I don't know that conservative isn't like defined specifically in the lawsuit, but that's kind of a helpful guideline in your mind when we're talking about the political subclass. So the second cause of action is the same thing, by plaintiffs on behalf of themselves and the political subclass against all the defendants. The defendants in this case are Google and 10 unnamed managers and executives. Their names are withheld because the plaintiffs aren't exactly sure who all it is. But we're talking board members and executives, and they will name them after discovery when they find out exactly who is in charge of some of these policies. So its cause of action is section 1102, which makes it illegal for an employer to threaten employees with discharge as a means of coercing or influencing the employee's political activities. Violation of section preventing employers from controlling political activities of employees gives employees a right of action for damages for breach of an employment contract. Now, before you get confused, an employment contract can be either a contract for a specific period of time. These are your union contracts, your labor contracts. People think of them, that as that's kind of the contract that people think of. But just an at-will employee who has an indefinite employment agreement or an employment relationship with an employer is in an employment contract as well. So don't get hung up on the idea that there may not be a specific paper that says you'll work for 3 years under these terms. If you're hired by an employer, you are under an employment contract, and breaching that contract will have different rules based on if it's a specific labor agreement. You'll have very specific clauses that can't be breached. If it's a general at-will sort of employment, there's going to be there will be different rules about what the breach may be. They're kind of established at what's called common law, which is case law that's been built up over really since the 1500s in England is where we get most of our common law. It's the legal system of England carried over into the U.S. when we separated from them and became an independent nation, and that those decisions have then built kind of the foundation for our common law. And then American common law really starts with Marbury versus Madison, as the Supreme Court started rendering decisions that really sculpted and molded legal interpretation in the United States. So a common law employment contract or a common law breach would be something like breach for discrimination of a protected class. Right, it is illegal to fire someone for being African American, for example. So even if they're an at-will employee, if you can show that they were fired for their race class, then that would be a breach of the employment contract. So kind of just, I want to make sure people aren't getting hung up on the idea of an employment contract being a very specific thing. It is a broadly used term in this context. So then plaintiffs in the political subclasses engaged in protected political activity. They expressed their political viewpoints, and then as a result, they were threatened and coerced through the respective class period by Google. Specifically, if you go through the facts section of this document, this is where some of the big problems for Google come in. You have several management personnel who appear to have hiring and promoting authorities making statements on Google's internal sort of message boards that they will not hire or promote certain people and will not allow them on their team based on what is arguably political activities or political affiliations. For example, Trump supporters, or for example, people who have specific beliefs about gender roles, or some people have a belief about the superiority maybe of heteronormative relationships. Those, as argued by Damore's attorney here, would be protected political speech and protected political activities, and therefore expressing those viewpoints cannot result in adverse hiring, promoting, or compensation decisions. And if you again go back to the facts section, you'll find numerous examples of managers who appear to admit to discriminating on those bases. And if you do that, that looks very much like it's a violation of California labor laws. So that's the real problem for Google. It's not really mentioned in these cause of actions, at least not in any of my highlighted sections, but there is a specific clause or specific section of the statute that does impute the actions of managers and executives who have authority, and HR departments who have authority over these hiring and promoting decisions. It imputes their decisions onto the company itself. So Google cannot make an argument, well, that was just a manager, and that's not the way that Google does things. That's just the way that this manager was doing things. They can't easily make that argument, especially if the person is still employed. Those actions by a hiring manager are presumed to be the actions of Google, and they would have to go to great lengths to kind of separate the actions of a rogue manager from Google's policies. The statute makes it clear that those actions are the actions of the employer. So the third cause of action, this is where we stray away from those California Labor Code, and we move into the, Can't record these videos without yawning. See, going through legal documents isn't just boring for you guys, right? It's also boring for lawyers. Just kidding. I'm joking. let me get personal with you. I have narcolepsy. So doing things like this does actually engage my narcoleptic tendencies, and it does raise my fatigue levels rather dramatically. So I apologize for yawning. I will try and keep it to a minimum. But it is my personal ailment that I deal with, and so there it is. It's out there for you guys to make fun of me for if you want. I really don't mind. I make fun of myself plenty. So this is moving away from the labor code and into the what's called the Fair Employment and Housing Act, which has some more rules that employers and I guess landlords would and real estate sellers, vendors, whoever would have to follow. In this case, of course, we're going to be worried about the employment sections. So, Fair Employment and Housing Act is abbreviated FEHA if you're listening to this and not watching it. So you won't see that. So this is by the plaintiffs, Damore and Goodeman, on behalf of themselves and the gender and race subclasses. So we've now moved away from the protected political activity. That is under the Labor Code. The Fair Employment and Housing Act is concerned with race and gender classes more than it's concerned with political activity, which it doesn't seem to be concerned with at all. So Google violated FEHA when they discriminated against plaintiff and the gender and race subclass members because of their gender and or race by taking account gender and or race when considering promotions, failing to protect employees from negative comments made about Caucasian men, as they protected members of other protected classes. So they're not just saying that they failed to protect Caucasian men. They're saying they did protect other classes that are similarly protected under statutes, but they singled out Caucasian men as the class not to protect. And that's probably where they, in these sort of negative action claims, like failure to protect, you really have to show that that the employer's going out of their way to isolate a class. Like, because if they fail to protect anybody, well, then they don't protect anybody. That's not really discriminatory, right? But if they protect other classes but fail to protect this class, that becomes discrimination. So, and finally, ignoring formal requests for redress from managers and the HR department. And this is another thing. This is when a member of a protected class brings these issues to their employer and says, hey, this is an ongoing issue. You have a legal obligation to protect me in the manner that you're protecting these other classes. Will you do that? And they ignore that. That adds into the cause of action for sort of a negative action. So that's the meat of the third cause of action. These start to get shorter as we go. Of course, as I say that, the fourth cause of action is a little longer, but there's a reason for that. So the fourth cause of action is workplace harassment in violation of the Fair Employment and Housing Act. This is just by the plaintiffs. So this is just Damore and Goodeman. This cause of action is not on behalf of the class. So what you've got here in the first three, you've got a couple very strong cause of action on behalf of the political class. You have a pretty strong cause of action on behalf of the race and gender classes, but we're relying on the similar set of facts to the previous ones. So the sections are getting a little shorter, but now you have more specific cause of action, so it gets a little longer and more specific to Damore and Goodeman. Okay, so we're on line 232 here. The Fair Employment Housing Act provides that it is unlawful for an employer to harass an employee because of the employee's gender and or race. Further, it is unlawful to harass an employee for informing internal management about possible violations of the law. So, if an employee, an employer can't harass someone because they're a particular color or gender, and they can't harass them if the employee in good faith brings up possible violations of the law. So Google, according to this, Google constantly treated plaintiffs in a discriminatory and harassing fashion after they reported labor code and California civil code violations. This created a hostile work environment. The harassment was based on gender or race, and reminders to Google not to break the law by taking into account protected categories and giving underrepresented minorities and women special preferences when making hiring or promotion decisions. So part of Damore's complaint, if you read his memo, or if you have read his memo, is that women and certain minorities were given preferential treatment in the hiring process, like with specific protections or specific circumstances for interviews or something to benefit these specific classes of people. Damore's argument is that this is a violation of California law. It's a good argument. It's not 100% set in stone, but it is a good argument that if you can't discriminate, for example, against African Americans or Hispanic Americans, then you probably can't discriminate against Caucasian Americans either. Google's conduct was so severe and pervasive that it altered plaintiffs' conditions of employment. This is just a critical factor of the statute. Google's treatment of plaintiffs caused them to consider the work environment to be hostile and or abusive. That's the subjective standard. The objective standard would be a reasonable person, and this is included, a reasonable person in the same circumstances would have similarly considered the work environment to be hostile and or abusive. So Damore and Gudeman are saying they are not specially sensitive actors in this. If you replace Damore or Gudeman with a similar white male, you will find a same reaction, that they would find the environment hostile and or abusive. I can say on a personal level that I have talked to some people in Google who do hold this view, that it is hostile and or abusive to be a conservative white male at Google. So those people are not Damore or Gudeman, whom I have never spoken with. But, I just want to let people know that whatever the merit of that claim, there are people who agree with Damore and Gudeman on this and actually do maintain their employment in fear based on their political views, their race, and their gender. So, 238. Plaintiffs have made it clear to Google that such harassment was unwelcome by reporting it to HR multiple times directly. Google did not act. And then Google's conduct is a substantial factor in causing the plaintiff's harm. The fifth cause of action, retaliation in violation of the Fair Employment Housing Act. So the California Government Code provides that it is unlawful for any employer or person to discriminate against any person because the person has opposed any practices forbidden under the Fair Employment Housing Act. Plaintiff opposed Google's unlawful hiring and promoting practices. This is a claim, right? The court has not actually found these to be unlawful. So this is a trigger to the court where if the judge determines the hiring and promoting practices to be unlawful, then this kicks in because the plaintiffs opposed those practices. Oh, I didn't mention, this again is specific to Damore and Gudeman and is not including the protected classes. So they opposed it by complaining to their supervisors in Google HR on several occasions. Plaintiffs reported to Google numerous occasions of hostile comments made by coworkers regarding the plaintiff's gender and or race. Plaintiffs further complained about the unlawful hiring and promoting practices. And then they alleged that in retaliation for objecting to such unlawful conduct in violation of the Fair Employment Housing Act, Google took adverse employment action by issuing written and verbal warnings and decreased performance reviews. So these are questions of fact. The facts that they have provided in the form of screenshots and statements do tend to look like this is the case. Again, I assume Google will provide a completely different factual scenario and may, what I assume they will do is attempt to provide alternative reasons for which Damore and Goodeman were terminated or received their negative performance reviews and various employment discipline actions. So they allege there is a causal link between the plaintiffs complaining to report Google's illegal activities, harassment, discrimination, and the subsequent retaliation. So then, in so retaliating, Google violated the FEHA, among other statutes and California common law. Speaking of that common law, the sixth cause of action is retaliation in violation of public policy. They have a case listed here, to many, and that's just a clue to the court as to what they're talking about here. Kind of a general reference. I won't go through the to many case. If you're interested, I do cover it in one of the previous videos. I think video 4, maybe 3. Sorry, I don't really remember. So this is again specific to Damore and Goodeman. Reprimanding employees in retaliation for resisting the violation of laws that secure important public policies contravenes those policies. So then that gives rise to a common law action in tort. So basically, this is where, let's say, California law has established a policy, a public policy against discrimination in the workplace based on race and gender, and then a workplace decides to discriminate based on race and gender, and then an employee says, no, I am not a part of this, and I will not participate in these events that violate the policy against discrimination. And the employer disciplines them in retaliation. That gives rise to a cause of action. So that's what's being alleged here. So plaintiffs were given verbal and written warnings after complaining about Google's unlawful hiring and promoting practices. And Google's violation of plaintiffs' statutory and constitutional rights is inconsistent and hostile to the public's interest. Google's arguments, so this is a preemptive argument against Google's response, but Google's arguments for reprimanding plaintiffs are pretextual in nature and calculated to disguise the motivating basis of the adverse employment action. So what you're finding here, this is language borrowed, I shouldn't say borrowed, but that was really prevalent in the 60s during the fight against segregation and as we started to incorporate and integrate races into workplaces and other areas. What would happen, be an employer would fire an African-American employee for something, but that was actually just a pretext for the firing of African-American employees in general. And they would go to start proving this by showing a consistent pattern of termination of African-American employees or negative work environments, statements, or hiring or promotion decisions against African-American employees. This is how you overcome the argument, especially in an at-will state like California, since Google is a non-union employer, that they were terminated for something else. It just so happens that they are white, male, and conservative. This is how you start to overcome that argument by saying those excuses are pretextual and they're disguising the real reason, which is this discrimination. So very common in discrimination suits to have a line like this to sort of preempt the argument that's going to come back. So this moves us into the seventh cause of action, retaliation in violation of California Labor Code 1102.5 by plaintiffs. So again, this is Damore and Goodeman against all defendants. So this is back to the Labor Code, and we did 1101 and 1102 generally. This is a specific section of 1102.5, and it's important for a reason I'm about to explain. So this provides that an employer or any person acting on behalf of the employer, I mentioned this earlier, right, shall not make, adopt, or enforce any rule, regulation, or policy preventing an employee from disclosing information. And then I'm going to skip the next part because it's irrelevant. So, to a person with authority over the employee, or to another employee who has the authority to investigate, discover, or correct the violation or non-compliance. So that would be like HR. Or for example, if you have sort of a discrimination or safe workplace officer, someone whose job it is to maintain the anti-discrimination sort of policies in in smaller environments, because when you got a corporation as large as Google with something like 80,000 employees, you can't just have one centralized person dealing with all this stuff. You often have to have appointed people in small groups monitoring this on a more micro level rather than just the macro level. So it further provides an employer, or any person acting on behalf of the employer should not retaliate against an employee for refusing to participate in an activity that would result in a violation of state or federal statute. So in this case, if the discrimination alleged above to this point were to violate California statutes, then an employee who refuses to participate in those violating activities can't be disciplined or terminated or whatever. So then this moves us to the 8th cause of action. This is a failure. What you'll notice about these is the claims do start to get a little weaker. The arguments are a little bit less strong as we go. The initial claims are very good. The ones that are statute specific are very good. The common law claims, the failure to act claims, those are going to be your weaker claims sprinkled into these causes of action. That's just kind of the nature of them. It doesn't mean that they're going to lose or win or whatever, but they just aren't as easily grounded in argument as the statute says this, the courts interpret the statute this way, this is why we win. These are a little more intangible, we'll say. So failure to prevent discrimination, harassment, and retaliation in violation of the Fair Employment Housing Act by the plaintiffs. Again, this is Damore and Goodeman only, not including the classes. So they say that at all relevant times in this suit, Google was required but failed to take all reasonable steps necessary to prevent discrimination, harassment, and retaliation under California Government Code 12940 subsection K. So upon information and belief, so this is a little insurance policy here because these complaints are made under oath. So they're stating that to their best knowledge, Google's lack of any meaningful investigation into the plaintiff's complaints of coworkers' discriminatory, harassing, and retaliatory behavior constituted failure to prevent discrimination under the FEHA. So they believe that Google lacked any meaningful investigation. Just based on, this is largely based on Damore and Goodeman both requesting some information about why they were being terminated or why they were being disciplined and not being provided with it, even though they had, they had sent some things to HR and they expected to have information come back from HR for them, and it never did. So based on that, they don't believe that a meaningful investigation took place. So this upon information and belief indicates that this is an opinion. And then basically, if Google comes back and says, no, we absolutely did an investigation, and the fact that they're saying otherwise is like a misstatement or misleading statement, they're going to say, no, we just weren't aware. We weren't able to get this information from you up until now. And then at that point, they would presumably kind of retract that portion of the claim. So the 9th cause of action is unfair business practices, Business and Professional Code, section 17200. This is by Damore and Goodeman on behalf of themselves and all of the plaintiff classes against all of the defendants. So this is everybody again. And this is one of the weaker claims, but basically Google's violations of the California Labor Code and California statutory and common law and other provisions constitute unfair and unlawful business practices pursuant to Business and Professional Code section 17200. Now, what this basically says is that if they're violating the law, that amounts to an unfair business practice. Just the violation of the law in general amounts to an unfair business practice. And there's some specific relief that is allowed for these types of claims. They rely on when I say they're weaker, they're just very vague. But if basically any of the statutes are considered violated, this one is probably violated as well. It's kind of a catch-all, and it may provide some extra relief to the class members, or just extra attorney's fees for their attorney, as class actions tend to go. The 10th cause of action is for declaratory relief, and this is by all plaintiffs on behalf of themselves and the subclasses against all defendants. So declaratory relief, they kind of lay it here, but when you have an actual controversy, a genuine controversy of law, you can ask the court, when you believe that the controversy will continue, you can ask the court to make a declaration that those particular actions are illegal and they need to cease immediately. So what they've stated here is that an actual controversy has arisen and now exists between the parties. Plaintiffs and the subclasses desire a declaration of rights and other relief available pursuant to the California Declaratory Judgment Act. They say that this judgment is necessary and proper because Google has continued and upon information and belief, or well, no, it doesn't say that. And continues to commit violations. Okay, here we go. Set forth above, and on information and belief, Google will deny that it has done so and or will continue to commit such acts. So they want a clear statement from the court that Google's activity has been illegal and will continue to be illegal, and that therefore, if Google were to continue doing these things, the next group of people would have a much easier route to relief, as Google has been told by the court that this is an unlawful act. So those are the 10 causes of action. Many of them, based on the facts provided, are very strong. Those facts include screenshots from hiring managers at Google stating that they will not hire people of a certain sort of political perspective, or they do make some potentially derogatory statements about Caucasian males. Now, they may not have meant them in a derogatory way, but they do, in a vacuum, come across that way. So remember that Google has a chance to respond to this, and the narrative of what's going on will be kind of refined by the opposing view. That's how this adversarial process works. Hopefully it brings us closer to the truth. Sometimes court is good at that, sometimes it's not. But we'll have to wait for Google's response to see. So we're at 48 minutes, and I want to try and fly through this memo as quickly as possible because I want you to know why the claims, especially the claims in Labor Code 1101 and 1102, are so strongly in favor of Damore's argument, at least in my opinion. So again, this memo, was written in 1986 by the Office of the Attorney General of California. I will say that this memo ended up being correct. After this memo was written, the courts agreed with this memo. In fact, this memo is cited in one at least, but I believe several cases regarding to employer discrimination of homosexual individuals. So the Office of the Attorney General was correct. This is not an authority, but it is a secondary source that carries very high persuasive value because it has been upheld and cited in Supreme Court or California Supreme Court cases. So just know that this is not a random opinion. It is a very highly regarded opinion. So I'm going to really try and stick to the highlighted sections here to move this along. So the conclusion of this document at the onset is that Labor Code sections 1101 and 1102 prohibit a private employer from discriminating on the basis of homosexual orientation or affiliation. Like I said, this document is not a direct corollary to the Damore claims. Obviously, he's not claiming protected status as a homosexual, so that does not apply to him. However, it is informative and instructive about what the scope of the law is prior to this. But what you need to do is when you look at this document, they've taken section 1101 and 1102 and through reasoned argument and the way that the court has applied decisions in the past, decided to expand the protections of these two statutes to include homosexual orientation or affiliation. Prior to this, it was not a guarantee that that was a protected class in this way. The protections that predate the homosexual orientation or affiliation are more broadly related to what are more traditional political activities. I'm trying to be very clear on this because one of the counter arguments that I myself have fronted in this case is that Google may not, or California law, it doesn't matter what Google considers, California law may not consider white male conservatives to be a protected class due to their presumed privileged status. Okay, this is an argument that we find in the social context, not as much in the legal context, but that to be negatively discriminated against, you have to lack privilege or power. So racism, for example, is discrimination plus power. Is kind of a mantra, I believe. Again, I'm an amateur at this, at the social justice field, but that's kind of a mantra, and that's why you'll find certain activists stating that minorities or women are not allowed to, or not able to. I shouldn't say not allowed. They're not able to be discriminatory or racist or bigoted because they lack the power required to do so. The law does not operate in that way. And so, again, let's be very clear that this memo is an expansion of protection to homosexual orientation or affiliating people from the existing protection for general political activity. Okay? So this question is related to a private employer, which is relevant here because Google is a private employer, not a state employer. If this were a state employment system and not Google, the case would be even stronger. But this is a private employer, and this memo is relating to private employer. So statutes were originally enacted as a single section, so just as, not as 1101, but something similar in 1915. They were recast as two separate sections in 1937 in their current form. They have remained that way pretty much ever since. So we've got 80 years of consistent law, of consistent language being applied here. Courts have usually interpreted this to defend employees engaged in traditional political activity from reprisal by their employer. In the Lockheed aircraft, the Supreme Court commented that the statute concerned activities related to or connected with the orderly conduct of government and the peaceful organization, regulation, and administration of the government. Remember, I mentioned earlier that the Lockheed case was Lockheed firing several employees who were talking openly about violent uprising or overthrow of specific areas of the government. So they were fired for that. That was not considered protected political activity. Only orderly and peaceful organization of government. So participating in elections, affiliating yourself with a political candidate or a political party, those are legitimate government activities or political activities. Saying that we need to burn the system down and hang all of the legislators, probably not okay. The sections protect the fundamental right of employees in general to engage in political activity without interference by employers. So the legislature did this so that there would be suitable protection of health and safety, so that peace and good order may be promoted through regulations designed to ensure wholesome conditions of work and freedom from oppression. So according to the Attorney General, the most difficult interpretive issue is figuring out which types of political action and affiliations are protected against arbitrary action by a private employer. And it is important that it is arbitrary action. If an employer has cause to terminate or discipline an employee, that's okay. They can do that if they have cause. But if the action appears arbitrary, or if the cause that they front is, as claimed, pretextual to the arbitrary actions, then that, that's what's protected. Is protection from this arbitrary action. The court first determined that the protection for political activities could not be narrowly confined to partisan activity on behalf of a political party. So, what we need to take out of this statement is that partisan activity on behalf of a political party is a protected political activity, but the statute goes beyond that. It protects more broad categories than just that. So, reviewing decisions of the U.S. Supreme Court, it noted that participation in litigation, it being the California Supreme Court, participation in litigation, so lawsuits, the wearing of symbolic armbands, so dressing in a certain way or adopting certain symbols, and the association with others for the advancement of beliefs and ideas had all been held to be political activities. So again, so long as it is peaceful and within the scope of organized government or the orderly conduct of government, you are protected for affiliating with whoever, no matter what the other person thinks is appropriate. Like if someone thinks it's hateful to be Republican, being Republican is still a protected political act. Okay, even if it highly offends a person that someone would dare support Donald Trump. Donald Trump was a legitimate candidate for legally legitimate candidate for president. I know. Please don't take umbrage with the fact that he is a legitimate candidate. If you think that he is unqualified or whatever, that's not what I'm talking about. I meant that he went through the legal process and appears to meet the constitutional requirements for the presidency. So he's a legitimate candidate for president. Supporting him is part of the orderly conduct of government and peaceful organization. Even if you disagree, even if you find Mr. Trump to be vitriolic, even if you find him to be racist or bigoted, supporting him cannot be an unprotected political activity. It must be protected because it's part of the orderly conduct of government. Okay. The background of this, according to the California court, is that these cases define political activity in broad terms. This is supportive of Damore's argument here, that political activity is broadly defined. What Damore will argue is that political activity is one that anything where you're discussing the relationship of race and gender, or the interrelationship of race and gender, in the race and gender roles, and certainly statute and law regarding the hiring practices relating to race and gender is going to be protected political activity. So the Office of the Attorney General finds it quite improbable that the legislature could have intended that it would be permissible for an employer to discriminate against an employee on the basis of undeclared political beliefs, while at the same time the employer was prohibited from discriminating against an employee on the basis of openly expressed political views. So here they're addressing the question of whether homosexuals who are not open about their affiliation or their orientation could be similarly discriminated against. They dismiss this. If they can't bar against overt people who openly identify as one thing, they certainly can't discriminate against people who keep their beliefs to themselves. It is obvious that the legislature has barred, for example, the discharge of an employee who openly declares himself or herself to be affiliated with the Republican or Democrat Party by reason of that party association. So again, it is obvious that it is not okay to fire an employee who identifies as Republican or Democrat. This is a big part of Damore's argument, that their political identity is the basis for the discipline against them. We cannot imagine that the legislature intended to grant permission to an employer to have a policy permitting discharge of employees on the basis of the employer's belief that an employee is a covert Republican or a secret Democrat. It appears to have been the legislature's judgment that political activities are not within the purview of an employer's legitimate interests, and that political activities or affiliations, whether private or public, should not be tolerated as the basis for employment decisions. That statement should be terrifying to Google. Based on the facts provided in the Damore suit, they tend to promote a specific culture of a specific view of political matters. What can certainly be considered political matters, and that would be transgenderism, or gender roles, or promoting diversity for the sake of diversity, stuff like that. All of that potentially runs afoul of this language right here. So this conclusion bars any employer from any policy, quote, tending to control or direct the political activities or affiliations of employees. Similarly, Section 1102 bars any employer from attempting to coerce or influence an employee, quote, to adopt or follow or refrain from adopting or following any particular course of line of political action or political activity. So forcing people to, remember, this is talking about sexual orientation. So forcing people to acknowledge a sexual orientation as legitimate, or forcing an employee to determine a sexual orientation to be illegitimate is probably not okay. Neither one is okay. Returning to the analogy of employees with undisclosed affiliations with the political party, we can see that if an employer had a policy of discharging employees believed to be secretly associated with the Democratic Party, employees who are actually oriented in that direction would feel pressured to either declare themselves publicly as Democrats in order to secure protection, or to declare themselves as Republicans in order to placate their employer. Those whose private orientation was toward the Republican Party would feel a similar compulsion to convince their employer of their orientation. So this section is just basically saying that these policies force people to come out into the open, either in support or opposed to other political thought, to either invoke the protection of the statute or to comply with the employer, and that's not okay. The employer cannot coerce employees through these policies into declaring one thing or another, or supporting one thing or another. Part of the allegation in the lawsuit, if I remember correctly, is that Damore basically says that Google forces people to affirm various I don't know exactly how to put it, but LGBTQ and other subcategories of identity. Google openly affirms them and appears to, based on, again, the facts laid out in the Damore and Gudeman suit, appears to require its employees to similarly affirm things that the employees may find contradictory to their morals or values or political ideology or something. Okay? So the effect of the policy would be to force the company's employees into particular courses of political activities. That's not okay under the statutes. Finally, interpreting the provisions of the labor code to permit employers to have a policy of discharging employees on the basis of the employer's beliefs concerning the sexual orientation of its employees would have a marked chilling effect upon the willingness of those employees to take the political action of declaring their sexual orientation. Mind you, this is not limited to homosexuality. If a company seems to value homosexuality above heterosexuality to the point where it would make an employee question whether he should identify himself openly as a heterosexual, that is similarly discriminatory under the law. It may not be similarly discriminatory in the opinion of some people in the social context, but in the legal context it is. And you're not in the social world in a lawsuit. You're in the legal world. So it would violate the letter and the spirit of the two labor code sections we have been discussing. So that's that. We're right at an hour and 5 minutes. And so I'm going to wrap this up. But look, I hope this has been instructive in some way in distilling some of these legal issues in a very, I guess, straightforward manner, as fast as I can possibly do them with any sort of thoroughness. But the long story short, the 30-second snippet on this is, according to the facts alleged by Damore and Guterman, they have a valid cause of action against Google and are likely to recover. That said, we have to wait and see what Google's counter, I guess, what their answer looks like. Google is likely going to move to dismiss this claim for failure to state a claim, because that's kind of standard civil practice. If this survives that, and I think at this point it will, because there's just so much that Google will have to disagree with, so I think it'll survive that dismissal. Google will be forced to answer. Their answer will present a counterfactual narrative that will show why it was justified in terminating or disciplining or reprimanding various employees who seem to be either the direct to Damore and Guterman, or who seem to be representatives of their classes. I assume with Damore, they're going to talk about the negative publicity they received when his memo was published outside of Google. I don't know if that's true or not, but I think that's what they'll be going after. I think they will also try and find in internal postings statements by Damore and Guterman that would lead to disciplinary action outside of protected political speech. But I don't know. We have to wait for their document. It'll be very interesting. Please check back when Google goes ahead to release and releases their document when they file. Unfortunately, I don't know when that will be. It could be as late as May at this point, because the court has found this to be a complex legal issue and has extended the timelines. Google could file technically today, but it may be as late as, I believe, May 4th, 5th, something like that. But if you subscribe to my channel, you'll get a notification when I do any videos on the Google lawsuit. If you have questions about what is in this suit, watch my previous 4 videos. You'll get a lot of information, but you will get some spicy dialogue and banter. It's all in fun. This is an entertainment videos cast channel, something on YouTube. It is informative. I try to be as informative as possible, but we also try and keep it light. And so yes, there's some entertainment value that some people may find objectionable, especially ones who are named specifically in the suit. If you are not interested in that, don't watch. I won't be offended. But if you are interested in getting a bunch more information about the specific facts that are alleged, go watch my other videos. They're very thorough. Like I said, we go line by line through the whole thing. You'll also get a more in-depth look at those causes of action. I bring out the language of the statutes, and I believe I also talk about some of the cases that they reference specifically. But yeah, that's that. Housekeeping is done. You can check me out on patreon.com/lawsplaining. All of my social media links are in the description. If you have questions about this, if you want to yell at me or whatever, drop them in the comments on YouTube. Send me a message on Facebook. Find me on Gab, Minds, Twitter, wherever. Engage me on this, and I will in good faith engage you back and try and answer your questions, or address particular situations or hypotheticals. I'm happy to do that. Again, I'm not involved in this case. I can talk about it all day. Anything that's publicly available is open fodder. So I hope you have found this video palatable and within the Googley way as best as possible. If you do find it to be informative, please pass it around to your friends and coworkers who might be interested in this case and interested in an analysis of the suit and the claims as they stand today. And remember, they could change very quickly when Google's answer comes out, and to stay tuned for that. So this has been Lawsplaining the Interwebs with me, your host, Nick Rekieta. And y'all have a good night. I am going to go to sleep. Peace.